I'm starting. Hi, everybody. Thanks for joining us on this beautiful July summer evening. We're happy that you're sharing your time with us. We're very excited. I'm Nancy Morgan. I'm the coordinator of the Big Money Out Virginia, which is also affiliated with American Promise, which works on an amendment to the U.S. Constitution to get money out of politics. So I'm just going to start sharing my screen. We have an hour and we're joined by David Kolker, who is a senior counsel for the Campaign Legal Center. What we're going to do is basically over the next hour, we're going to do a sort of a semi-deep dive into the issue of money and politics. Why should we care about it? Some of the perspectives of Virginia. David will introduce how did we get here? What is the history of campaign finance? Opportunities for reform and entry points for action. And after David gives his presentation, I'm asking my colleague, Bill Millhauser, to come in, and we encourage people to put money. Yes, we'll take money, but put questions in the chat. And we really want you to ask all the questions that you want to ask, because we recognize that campaign finance it's not a very sexy topic. It's very technically, legally complicated, but at the end of the day, it affects probably every issue that everybody in this room, chat room, is interested in. So we're excited also because we have about 50 people who RSVP'd. 11, and we've got at least 11 states represented if everybody comes on. I was talking to Dave and I was going, oh my God, there's people from Oklahoma, which is like, it's wonderful. Every place from Maine to Michigan to Minnesota to Washington State to California to Florida, Texas, and Oklahoma. So we're looking forward to having a discussion, having people put any questions that you have in the chat. And let's just start off with the issue of money and politics. And I think that everybody agrees, when you look over the last 50 years, and the Pew Research Center has documented this, there's an erosion in confidence in our democratic institutions. And in the late 1950s, approximately 79% of Americans had confidence that government was working for them. And by 2020, they had a poll that said that basically 20% of Americans. There was a CBS poll in 2022 where 72% of Americans felt democracy is under threat. Obviously, the threat differs depending whether you're on the right or the left. But we were really interested that they did another survey in saying, what are the major threats to democracy? And one of the key issues, 86% of Americans, irrespective of party, believe that the money in politics is having an adverse impact on trust in our institutions. So I think there's a real consensus that this is a bipartisan issue that needs to be addressed by all Americans. What is American Promise? What is Big Money Out VA? I'm the coordinator of Money and Big Money Out. We have Bill Millhauser. We have some of our members here. It's a cross-partisan nonprofit organization empowering citizen advocacy action in all 50 states to get money out of politics. And nationally, federally, we were advocating for a constitutional amendment to the U.S. Constitution, and we're hoping, and I'm sure that David will get into how we are here, how we got here through 40 years of Supreme Court rulings that have basically eroded the rights of citizens and given them to corporations and special interests. So, as you know, through our history, Supreme Court rulings can only be addressed through a constitutional amendment, which is why we're focusing on that. But when our group started like 6 years ago, we were like, oh my God, I didn't realize that Virginia was such a pay-to-play state. Seriously, it's like it has some of the most lax campaign finance laws in the country. So we've been focusing on that. And why should we care about money in politics? Because we, the people, not money, super PACs or corporations govern. And when you look at it, everybody in the room has a different entry point for why they should care about money in politics. As I said, it's not a sexy interest issue, but if you're interested in Virginia energy policies, what is the role of Dominion, climate change, spiraling drug prices, dysfunctional healthcare system, mass incarceration, private prisons. I tell you that GEO, which is the company that operates private prisons, is giving money to Virginia legislators. So this is an issue. Nursing home care, regulations, broadband, and most recently, school boards and education. And if any of you are from Loudoun County, we were like the epicenter in 2021. And I just took the opportunity to put up the sign, the Moms for Liberty, which says that they're basically a grassroots organization that is getting their money from selling T-shirts, whereas they're getting all their money from dark money, right-wing groups that are basically sort of opposed to public education. And just to let you know, the Fairfax Democrats did a wonderful 2-hour review of dark money in our educational system, which I'll send out to you all. They just sent out this was like 2 weeks ago, and they sent out the audio of that. The video of it was excellent. So let's just take a look. I'm an economist. I look at graphs. I look at data. You can just say there's something happening with money in politics. And 2020 was a blowout year in terms of money in politics. The red is obviously the presidential, and the blue is the congressional. You had $500 million races in major states like Arizona, Georgia. You looked at that. It was just crazy in 2020. 2022, it's like, oh my goodness, it went down a little bit. But when you look at this data come from Open Secrets, which is a national organization to follow the money, including dark money or independent expenditures, 25% of the 2022 cost of elections, 2.3 billion, they allocated to independent expenditures. And I'll leave it to David to talk about the universe of independent expenditures, which includes dark money, gray money, green money, and then the super PACs, which have to report to the Federal Elections Committee. But I'll let him explain that, because it's an important issue, and he knows everything, having worked for 20 years at the Federal Elections Commission. In an American Promise, we believe that there's a constitutional amendment, opportunity here. We have some language for our Freedom Amendment. The whole idea of it's to regulate election spending. Why? So we can protect our freedom, have our voices heard, and participate as equal citizens in our government. I think everybody realizes that the constitutional amendment is sort of the only mechanism for permanently addressing Supreme Court rulings. So we are hoping to get that done. There are constitutional amendments that have been introduced in the 117th Congress and the 118th Congress, including Representative McGovern that just introduced one just a couple of weeks ago. The nice thing about this issue is there's a consensus among Americans that this is issue. 75% of Americans support the idea that we need to get a constitutional amendment. And interestingly enough, when you look at polling, 66% of Republicans believe this. So of any issue which could possibly get support on a constitutional amendment, this must be it. And in fact, we did polling in Virginia through the Christopher Newport University, the Wasson Center, and the majority of Virginians support a constitutional amendment. Almost 80% support agree with the fact that large donors have too much influence on our election, and 88% agree that all disclosures should be reported. So let's look at Virginia, which is probably a different issue. There's two sides of the campaign finance issue. There's a federal issues that affect federal elections, and they do affect state elections, as you saw with Citizens United, when 22 states had to change their state regulations, including most noticeably Montana, which had 100 years of campaign finance reform that they had to change. And if you want to watch a great documentary, watch Dark Money. It really, it makes you cry in terms of looking at state rights and money and politics. So look at Virginia. We have no dollar limits on any type of campaign donations. 45 other states do. It's Alabama, Oregon, Nebraska, and Utah who, along with Virginia, have no limits. No limits on corporations or special interests. 22 states have banned money from corporations and unions, and including the federal government since 1907, when the Tillman Act was introduced by Teddy Roosevelt, a Republican. No restrictions on politicians' personal use of campaign donations. Seriously, this is the lowest hanging fruit in terms of, do you want your money, your candidates to spend money on their son's college education, or going on vacation on the Bahamas, and limited regulatory oversight. And you can see that, you look at this graphically, I'm an economist, the same trend, but this has nothing to do with independent expenditures. This is because we have no limits. And when you look at the last 2021, when Youngkin ran as governor, I took this data from the Open Secrets, $148 million. And that doesn't include his ability to self-finance his election. That is just seriously outrageous. And what it means for Virginians is we have lost our voice, and Americans in generally have lost our voice. And this is just the data from the 2021 Virginia governor's race, almost the highest expenditures on elections in the country. And the worst thing is, largest donations above $10,000 contributed 75% of all Virginians. When you look at, do you give more than $500 to candidates? I don't. So you look at the people, 83% of donors contributed less than $500 to candidates, yet their contributions accounted for only 8% of total contributions. This is wrong. This is really, and this is up to Virginia legislators. They can take action on this. This would not be litigated under Citizens United. The states, and David will get into this, what are the rights of states? What is the influence of the Supreme Court ruling? But we can do something about this in Virginia. And I just dumped the data for the Virginia elections before the primary. They had to report to the Department of Elections before the primary, January 20th primary. And I took the $1 Million Club. There were 15 candidates that generated over $1 million. This is pre-primary. And the irony is, I took the data from Dominion and Clean Virginia, and you can tell there's just a dichotomy in who is supporting who and why. We're in a money arms war, and basically when you look at this is a lot of them are Democrats. 13 of them are Democrats, and most of them are incumbents. So this is a money arms war where people are trying to influence our election. There is no surprise why the Coalition for Integrity has rated us 46th on the Swamp Index. You can see Virginia 46. we're only 47. Utah, Michigan, Arizona, Idaho, and Wyoming. Interestingly enough, Oregon, I'm hoping that somebody from Common Cause Oregon had responded, because Oregon was trying to put in place campaign limits, and they are ranked 42. So, the question is, is Virginia going to get limits before Oregon? Maybe it's a race to the top, hopefully. Just to let you know, I mean, there have been lots of introduction of bills in terms of campaign finance. 2 years ago, there were 24 bills, which was just amazing. And last year there were 14 bills introduced. They ranged from restricting personal use of campaign donations, limits. There were at least three bills on limits, including banning money from foreign influence corporations, from Tim Anderson, a Republican, which actually is a good bill. It passed in Minnesota. Disclosure, a good independent expenditures, looking at forcing independent expenditures, dark money groups to reveal the top 3 sources of their of their donations, early disclosure, and a resolution supporting an amendment to the Constitution. Only one of them passed. And the year before, when 24 bills were introduced, one passed. So it's sort of a graveyard of, well, I shouldn't say that. It's an opportunity for reform. So now we're going to go to David Kolker, who's he talk about the ins and outs of campaign finance laws. How did we get here? And we're really excited that David is here. He's the senior counsel on campaign finance for the Campaign Legal Center, which is a nonpartisan national organization that really is the one that looks at the rights, at the laws, and has done extensive litigation. Every time I turn my head, they're doing something with the Federal Elections Commission in terms of appealing. Whether it's like you look at next year in terms of the presidential election and DeSantis sort of taking a PAC money and trying to convert it into super PACs. I mean, I don't think that is illegal. I don't think that's legal, but I think that David can tell us that. So we're really excited. He comes with 20 years, sorry, I doubled that. David, you're not that old. So 20 years of working with the Federal Elections Committee. So we're interested in learning all the secrets about the Federal Elections Committee, how to make that more effective. So David, I'm going to just turn over the proverbial microphone to you. Thanks so much for joining us.
Okay, Nancy, thanks for having me. So for the next portion, I'm going to do kind of a mini deep dive into campaign finance law, how it got to where it is, focusing on the federal. And because the Supreme Court, when they look at these laws, are using the First Amendment to analyze them, the rules that they set up about what Congress can do are going to apply to the states as well. So I have been doing campaign finance law since 1994. A lot of it at the Federal Election Commission. So the Federal Election Campaign Act, what is it? It's just about the money. It's not about lobbying. It's not about voting rights. It's not about gerrymandering. The key provisions include what we call disclosure, and disclosure really has two components. One is reporting. If you are regulated by the Act, you have to report information to the Federal Election Commission, and then it'll get put on the website for the whole world to see. And there are also what we call disclaimers. So if you run ads that are election ads, there's stuff at the bottom, paid for by David Kolker, not authorized by Nancy's campaign committee. And there are various rules about those. So those contemporaneous things that go on the ads are usually referred to as disclaimers, although that word doesn't appear in the Federal Election Campaign Act. Originally, the Act had limits on contributions, and by contributions, we mean money that you can give directly to a candidate or political party or a PAC, as well as limits on expenditures. And I am going to talk sort of originally in a minute. So when we talk about expenditures, that's money that candidates spend, that parties spend, whereas independent expenditures are money that is not given to anybody, but is used, say, to pay for ads. And it is purportedly independent, meaning that the candidate that's being supported hasn't been talked to about what the ad's going to say. There is kind of a hybrid called a coordinated expenditure. So if I, under current law, if I want to spend $1 million saying vote for Nancy for president, I can do that. There's no limit on what I can do. But if I coordinate with her and say, Nancy, I'm going to run this ad about gun control and puppies, is this okay with you? And she says, that's great. And then I run the ad, then it's a coordinated expenditure. And because the activity has been coordinated, it is treated as a contribution to Nancy as if it were a cash contribution, and therefore can be subject to the same limit. So under federal law, I can make coordinated expenditures for Nancy, but only up to $3,000. If I want to spend an unlimited amount of money, I have to do it independently of her. The Act regulates different kinds of entities differently. So there are different rules for candidates, political parties, PACs, corporations, and unions and individuals. So depending upon what kind of entity you are, that may mean that you have a different amount of money that you can give or receive. And if you think of it as a grid, these sort of different categories, who can give to whom and in what amount and what can be received. So there are different rules depending upon your status. The modern Campaign Finance Act that I've just summarize very briefly, came into being as a baby of Watergate. Thank God for Richard Nixon, or we wouldn't have the current FICA. Although the original law in this area was passed in 1907, revised in 25 and in 47, it wasn't really a strong statute until after Watergate, where some of that scandal involved money in politics, and Congress completely revamped the statute. However, 2 years later, the Supreme Court interpreted the statute in what is still the most important case in this area, Buckley versus Vallejo in 1976. Talk about judicial activism. The court just kind of rewrote the thing, slashing some of it, keeping some of it, narrowing some of it. And I'm going to spend the next few minutes talking about this decision, because if you just read the statute, it doesn't really tell you how the law works right now, because the statute was essentially rewritten by the Supreme Court. The Federal Election Commission was created as part of these amendments. So it didn't exist at all. There was no agency to enforce the FICA until 1974. It is designed to be a somewhat weak agency, but at least it does exist. So what did the Supreme Court do in Buckley versus Vallejo? It made a big distinction between contribution limits and spending limits. So it more or less upheld the contribution limits. It recognized that the idea of giving money directly to a candidate inherently presented a risk of corruption, or at least the appearance of corruption. But if you're spending money to support a candidate independently of that candidate, then maybe the candidate wouldn't like how you're spending, or maybe you wouldn't know about it. And when you write a check to the candidate as a contribution, that doesn't really have much of a speech component. It's just $500, $1,000, whatever. But if you do an independent expenditure, it actually says, vote for David because he believed in X. So that has a higher value speech element to it. So the court reviewed the limit on spending with more skepticism, what we call strict scrutiny, than it did with the contribution limits. It upheld the contribution limits. It struck down the limit on independent spending. It also struck down the limit on what a candidate could spend on his or her own campaign, which is why you had Ross Perot doing all that self-funding, and then Donald Trump and others. Originally, the FICA as amended in 74 would have limited what candidates could spend on their own campaigns. So it created this very important distinction between contributions and independent expenditures. It also then narrowed what even counted as an election ad. It said that the definition of election ad in the statute was kind of vague, but rather than strike it down, they would narrowly construe it, which is something that the court generally does when it's construing statutes. But what it said was, we're not going to consider it an election ad unless it expressly advocates for or against a candidate. So if you run an ad that says David Kolker beats his wife, kills puppies, he's a horrible human being, that's not an election ad, because it doesn't say anything about voting for or against me. So that was a result of a narrowing construction in the Buckley decision. It also narrowed the definition of what counted as a political committee or a PAC. By the way, many people think that PACs are bad things. PACs, as originally construed, were viewed as good things, because as originally written in the statute, the way it worked was big corporations, pick your name, Exxon, Ford Motor Company, they couldn't spend a dime on contributions or expenditures, but they could set up a PAC. And if their employees or stockholders voluntarily gave to that PAC, that money could be spent on elections. So the concept was, we wouldn't let their profits from selling gasoline or cars make its way into the election system. But if people associated with the corporation wanted to pool their money, knowing that it would be used for campaigning, that would be okay. And that's still kind of how the statute works. But what the court did in Buckley was say, if you're an organization, we're not going to consider you a PAC unless your major purpose is the nomination or election of candidate, the so-called major purpose test, which we still don't know exactly what it means. But the reason it's so important now, and I'm going to skip ahead here, is that when Citizens United opened up the door to unlimited campaign spending by corporations, if you're a 501c4 corporation and your major purpose is not campaign spending, which a lot of people means as long as you stay under 50%, then you don't have to be a PAC and you don't have to report anything about your donors to the FEC. So this narrowing construction of what constitutes a PAC back in the Buckley decision still is incredibly important today, because whether it's an LLC or for business corporation or a 501c4, unless your major purpose is election spending, you don't have to register as a PAC and report anything about your donors. So what happened after Buckley? Well, guess what? Because election ads were defined so narrowly, millions and millions of dollars were run on so-called issue ads that ripped people to shreds but didn't mention the election, and they were unregulated. The other thing that happened was that the political parties started taking in what we call soft money, because the national parties claimed, well, we do a lot of state activity, so that shouldn't be regulated by federal law. And they so a corporation couldn't give any money to a political party for federal purposes, but they could write $1 million check to the RNC for their state activity, their non-federal activity. And then this business of the issue ads, the so-called issue ads, and the soft money got married together. So the parties were taking millions of dollars, spending it on issue ads that just said Bob Dole's a great guy or Bill Clinton's a great guy, claiming they could use soft money to pay for these ads because they didn't qualify as election ads and were therefore not federal spending. So this is what led to the most recent major reform in this area, which was the McCain-Feingold reforms of 2002, formerly called BICRA, the Bipartisan Campaign Reform Act. So this banned soft money. That ban is still in effect. So political parties can take in more money than a regular candidate, but there is no such thing as soft money. So a corporation can't write an unlimited big check to some theoretical soft money account. That is still the law of the land. We won that in the McConnell case, and we haven't lost it since. The other thing that BICRA did, which was very clever, it said, we have to do something about these issue ads. So they made up a new thing called an electioneering communication. So if you run an ad 30 days before a primary or 60 days before a general election, and it merely mentions a candidate and it's broadcast, TV or radio, into the jurisdiction where the race is taking place, that counts as an electioneering communication, and it will be deemed an election ad subject to reporting. So if you run an ad that says David Kolker beats his wife, where I'm running for office right before the election, now that counts as an issue, as an election ad, even though it didn't say vote against me. So that was a major change, closing the so-called issue ad loophole. And then in McConnell, that was upheld. That was the latest big Supreme Court case after Buckley was McConnell in 2003. It upheld the ban on soft money. It upheld the new regulation of electioneering communications. And then Justice O'Connor retired from the court. She was the last serving justice who herself had been an elected official. And even though she was conservative, she often voted to uphold these laws because she knew how the system worked. She retired and Alito took her place. And we had a bad decision leading up to Citizens United. And then in 2010, we lost Citizens United. So the court overturned the decision in McConnell that had upheld the regulation of these new electioneering communications. It overturned another case that had upheld the ban on corporate independent expenditures. And it basically said this: we have decided that if you spend independently, by definition, as a matter of law, it simply cannot cause corruption. Kind of a mind-boggling thing, but that's what they ruled. And therefore they said, so even if corporations do spending, as long as it's independent, it can't cause corruption. Obviously, I think this is a horrible decision. It did at least uphold the disclosure for electioneering communications and express advocacy expenditures. And it even had language saying disclosure is great because everybody will know where the money's coming from. So there's no reason to ban this spending. The disclosures will take care of whatever lingering concerns there are about corruption. Right. And then what happened, and that's why a month after the case was decided, Obama in his State of the Union address called out the Supreme Court for this bad decision, saying it could open the door to foreign spending. And what he meant by that was, if money spent independently really can't cause any corruption, why not let Vladimir Putin spend $1 billion on our elections? Footnote, we had a follow-up case written by Judge Kavanaugh when he was on the DC Circuit upholding the ban on foreign spending, but not on corruption grounds, on the grounds that they simply weren't part of our democracy and don't get to participate. So what happens after Citizens United? Well, here's where I have to do a mea culpa because I feel personally responsible for super PACs. In the DC Circuit case, decided what we call en banc, with all 9 judges from the court participating. There was a case called Speech Now. And I argued the case unsuccessfully, lost it 9-0. I couldn't even get a vote from any of the Democratic appointees. And the reason for that was I literally argued the case a week after Citizens United. And the first question from the judge to my opposing counsel was, do you have anything to add to what Justice Kennedy told us last week? Justice Kennedy being the author of Citizens United. And what he meant by that was Citizens United had just ruled that independent spending cannot cause corruption. Well, what Speech Now was about how this ruling would affect PACs. Before Citizens United, you could only give $5,000 to a PAC. You couldn't give an unlimited money. And PACs could then use that money to make either contributions or independent expenditures. Speech Now was a test case. And what they said was, we don't want to make any contributions. We only want to make independent expenditures. We don't coordinate with parties. We don't coordinate with candidates. The Supreme Court told us in 1976 in Buckley that we individuals who were coming together to create this PAC, we're allowed to spend unlimited money on our own. Buckley said we could do that as long as it's done independently. So why can't we each put in an unlimited amount of money to a PAC as long as we only make independent expenditures, because they can't cause corruption? And after Citizens United, there was no way to win. So the court ruled 9-0 that PACs, if they limit their spending to independent spending and make no contributions, that they don't present a risk of corruption, and you can give an unlimited amount of money to a super PAC. And then in the wake of that decision, the FEC had no choice but to allow corporations to give to super PACs. And the other thing that happened was, even though Speech Now as an organization was going to give to lots of candidates, we've seen the rise of single candidate super PACs. And we've seen the rise of an official running for office having his brother-in-law set up a super PAC, wink, wink, nod, nod. Corporations and rich individuals give unlimited money to that PAC, and they theoretically spend it independently of the candidate, and therefore can take in unlimited money and spend unlimited money, furthering that person's candidacy. So that is a very brief history. So where are we now? What can we do now? What are the big topics now? Well, assuming that the decisions like Citizens United and Buckley are not overturned, the big issues that we can do something about is, first and foremost, disclosure of dark money. So what's happened is, even if you're a super PAC and you do have to report to the FEC about where your money has come from, Speech Now did uphold the disclosure 9-0 while they struck down the contribution limit. The problem is, when a PAC discloses where they got their money from, they only have to report their immediate donor. So pick your villain, George Soros, Charles Koch. You give $10 million to a limited liability corporation, Acme Inc. And then Acme Inc. gives $1 million to a super PAC. Super PAC has to report that $1 million contribution, but all they have to report is that it came from Acme Inc. And there may be no way to know where Acme Inc. got its money because it's just a corporation. And if its major purpose is not campaign activity, then it doesn't have to report as a PAC itself. Or you can give $1 million to an LLC, Americans for Charity, give them $10 million, and then they give it to super PACs. And all that will be reported as the super PAC's donor is Americans for Charity, not where the money really came from. We can do something about that. We at Campaign Legal Center were very involved with helping people in Alaska and Arizona craft ballot measures. The one in Arizona is the one we're most happy with because it's very, very robust. It passed, and I'm going to pick up on what Nancy was saying about the bipartisan support. In Arizona, a deeply divided blue and red state, this ballot measure to reveal the sources of dark money passed with 72% approval of the voters in Arizona. Of course, when you poke the bear, you get sued. So we have 2 lawsuits trying to strike down the new Arizona ballot measure. One in state court and one in federal court. The federal court case was brought by Americans for Prosperity. The state court case, we've already had one decision from the trial level judge in our favor. The federal case is newer, and we just finished the first round of briefing, no argument or decision yet. So there is something we can do about that. And the reason we have this dark money problem is that you can route money, wealthy individuals or for-profit corporations, whatever, can route money through these front groups. And typical reporting requirements don't go more than one step back. What do we do about super PACs? Well, the main thing we can do about super PACs is deal with the phony independence. Right now, the federal rules about what constitutes a coordinated expenditure are very weak. They obsess over coordination over a particular ad. In my view, if I'm running for office and I go raise money for a super PAC, I think every dime they then spend should be deemed coordinated if it's to help me. The current regulations at the FEC don't address anything like that. The other thing that people do is, like, the candidate sets up the super PAC before he's a candidate and then claims he didn't coordinate as a candidate because he set it up ahead of time, or his brother does it or whatever. So we have to deal with the relationships between the candidate and the people running the super PAC. You know, former chief of staff leaves the campaign, sets up the super PAC. Guess what? They don't need to discuss coordination. They know what is in each other's heads. We can do something about that by tightening up the coordination rules, because if the PAC is coordinating, they can't be a super PAC anymore. Other things we can do, I mentioned that when McCain-Feingold regulated these electioneering communications, as long as you mention the candidate's name just before the election, it only covers TV and radio. That law was enacted before internet ads. So the same ad run on TV that says, you know, David Kolker beats his wife, if it's on TV, it's an electioneering communication and reporting rules apply. If it's run on the internet on Facebook, it's not an election ad. That loophole can be closed at the state and federal level. The next thing that can be done is to deal with foreign corporations. Under federal law, the only part of the federal statute that covers state and local elections has to do with contributions or spending by foreigners. So under current federal law, it's illegal for any foreigner to give money to a state or local or federal candidate, or to make an independent expenditure for or against any state, federal, or local candidate. But that law has not been revised since Citizens United. It was written at a time when corporations couldn't do these things. So what if you have a corporation that's, you know, 50% owned by the Russian government? There are huge loopholes there. And we've worked on model legislation to fix that. States can do something about that, about foreign corporations influencing state and local elections. There have been bills introduced in Congress, but nothing's happened with it yet. And then finally, obviously, public financing. If you have public financing, you can do a lot to ameliorate the problems we have. And public financing programs tend to have 2 different flavors. You can get a pot of money if you qualify, or you can have matching funds. So for every dollar you raise, it'll be matched 6 to 1. They're both great systems. They would do a lot of good. They aren't more controversial than things like disclosure. Public financing is labeled by our enemies as, you know, taxpayer spending on corrupt candidates, and it doesn't poll as well and do as well as disclosure. There are limits to how much public finance can fix the system, because you can't limit under current law the huge outside spending. So even if you have public financing, you have less corruption directly with the candidates, but that won't by itself stop the super PACs by overwhelming the candidates' spending if they have unlimited money and will. But it is something that a lot of people think would do a lot of good. So I will stop there. That is a very quick overview, and I will turn it back to Nancy.
I'm muted. Bill, I noticed that April had a question. Do you wanna?
Yeah, April asked, is the Biden administration tightening the rules under the FEC's jurisdiction that covers super PACs and other areas?
The short answer is no, for a variety of reasons. The good thing about one of the good things about the FEC is that it's an independent agency. So it has, the bad thing about the agency is that it has 6 commissioners, 3 from each political party, and it deadlocks on virtually anything of any great importance. The good news about the way it's set up is when a new president comes in, he doesn't get to replace who's on the commission. He doesn't even get to pick the chairman. So when I worked there, it didn't really matter who was president. The president and the White House generally simply is hands off what the FEC does. The only exception to that is the Department of Justice. If you criminally violate the Federal Election Campaign Act, DOJ can prosecute you. And that is not as independent from the White House. I mean, the whole Justice Department is to some extent, but that role is not the FEC's. The FEC has no criminal jurisdiction. But in terms of rules, Justice doesn't write those. They just enforce and prosecute against people who have criminally violated, which is a tough standard to meet, these laws. The FEC currently is doing nothing about super PACs. And there's nothing that Biden administration can do to force them to do that.
Okay. Monica had a question on public funding of partisan primaries in Virginia. And Monica, I'm not sure what you were asking on that.
Sorry, I was just making a comment because of the statement about public funding for campaigns. And I just was making a comment of fact. I find it ironic that partisan primaries are publicly funded. The localities have to pay for them already. So, you know, just the point there.
Yeah, and I would just, thank you, Monica. I would just throw in there, that's not required. We helped write the ballot measure that passed in Alaska, and they created an open primary system where everybody runs in the same primary, regardless of your political party. You can say, I think of myself as a Democrat, but nobody is nominated by either party. And then the top 4 make it to the general election, regardless of their party affiliation. And this was challenged in Alaska courts. And the parties argued, this is like, you know, discriminating against us. But the premise of their argument was flawed. They have no right in the first place to have the government pay for their primary. If they wanted to have a primary, they could still have one. It's just Alaska wasn't going to pay for it anymore. And that was thrown out by the courts. And that went all the way to the Alaska Supreme Court.
Yeah, and I would just add on that in Alaska, the final 4 candidates run in a ranked choice voting election. And of course, that was very controversial this last year.
Yes, that was all part of the same ballot measure.
Right, same thing. Heidi has a question on which states have the most successful public funding programs, Maine, Connecticut, or other, and should we pursue a clean elections program here in Virginia before we seek to impose contribution limits, or should we do that in tandem with the campaign finance reform?
Well, I hesitate to give specific advice, but I will make a couple of comments. I'm not really in a position to comment which is the most successful. I will, I've heard good things about the Connecticut program from the woman who used to help run it. I will say that what I've heard the most about is the one in New York City, which was a matching program, where it was like 6-to-1. And what I really loved about what I heard about that program is that it changed the way the candidates behaved, so that a candidate could go to somebody's house where there were 30 people and they were each just going to give $50, because that $50 was going to get turned into $300 by the match. So it made the candidates, or at least encouraged them to behave differently in terms of their constituent outreach and communication. And I thought that was a beautiful effect of the program. The other thing I should mention about public financing is that the other kind is a voucher program like what they had in Seattle. Everybody in Seattle has a right to get like 4 $25 vouchers, and they can give them to any candidate they want to. Not too many people participate, but it's a nice program. In terms of what to pursue, again, I'm not going to give you advice. I will just say this. If you're going to consider it, you need to do polling. My understanding is that disclosure of dark money usually polls close to 80%. In Arizona, we passed with 72%. Public financing does not. And the concern is that if you marry the two together, the public financing could lead to a defeat. In Alaska, when the ballot measure passed, the people who were behind it, I think it's fair to say, were most interested in the open primaries and the ranked choice voting. They were interested in the disclosure, but that was not sort of the main driving force. I am told that when they publicized the ballot measure, the disclosure part was front center of their publicity because they knew that it polled so well. This thing passed 50.5% to 49.5%. And in fact, when the lawyer challenging the ballot measure's open primary system went to court, he wasn't a very good lawyer, but the stupidest thing he said to the judge was, you shouldn't really take this statute seriously, this open primary thing, because it only passed because people wanted the disclosure. People didn't really want this. And of course, judges can't think about it that way. The law is the law. But I tell you that anecdote because I think it reveals something about what happens when you put things together. So if you want to consume an omnibus thing, think about how it's going to poll and what you can learn about how voters are going to feel about it.
Yeah, if I may also, just from a Virginia standpoint, because there have been bills introduced on public financing. It was Marcus Simon one year, he introduced it. It was the democracy voucher program like Seattle. And it was defeated just because of the financial issues. And then he introduced something to allow it to happen at a local level. And I don't think it even got a hearing. But the issue with public financing, and that CLC has a great, they've done a lot of work on the Brenner Center for Justice. And there are 14 states that currently have it. And New York State just introduced it, but it was a fiasco because it was a grant program, small donor grant program. It was supposed to be matching to $2,500. And at the end, they wanted to raise it to $18,000, which was just, and the issue with public financing, and even Democrats, it's the concern about using taxpayer dollars. So, and the Connecticut example is a very useful one because they have a sustainable revenue source from unsold assets or something, abandoned assets. Arizona also have it. So they find financing that is not coming from taxpayers, which I think is much more acceptable by certainly Republicans and a lot of Democrats. And I was, Irene Shen is very interested in this issue. And I think combined with limits, because you talked about limits in Virginia, and people outside of Northern Virginia are saying, yeah, but it's really difficult outside of Northern Virginia to get people to give you money. And so I think even Republicans are interested in the idea of this sort of public financing, but it would have to be really messaged well, that it's saying it's not taxpayer dollared, and you're right. And it probably couldn't be coupled because it would die an early death. And you really have to sensitize people as to what actually that means. So I think it's a wonderful opportunity in New York City. The amount of diversity that they have of candidates running. So it's a great program, but it isn't a panacea. And I think that people need to be sort of very cautious, like David said, do polling and do a lot of advocacy on this issue.
And I'm not an expert on this aspect of Virginia law, but in certain states, if you pass a measure that's going to cost money, the measure itself has to provide the funding for it. And that can be part of the state constitution. So you would need to figure out in Virginia, or if you're not in Virginia and you're participating tonight, how your state deals with laws that spend a bunch of money, whether they have to have embedded in it a funding source.
Yeah.
Bill, any other questions?
Yeah, Patty had a question about the funding of the FEC and its ability to provide sufficient oversight of federal campaigns. I think she presumed that it's maybe underfunded.
Yeah, I was there for 18 years. I still know people who were there. I don't think it's funding as much of a problem. I mean, agencies can always use more money. The problem right now is the commission. There's a big branch of lawyers within what's called the Office of General Counsel. And the way it works under FICA is, if I think, Hillary or Trump have violated the law, I can't just sue them. I can file a complaint with the FEC and they have to look into it. Basically this big branch of the FEC isn't even doing any investigations because the Republican commissioners, and I'm overgeneralizing, but they're just not even authorizing investigations, or if they are, they're very limited. So I don't think and they're not doing regulations. I mean, they haven't done a whole bunch of regulations that they should have in the wake of Citizens United. There are commissioners who want to do a reg about how to treat foreign corporations. And the agency, I think, has the power to fill in that gap after Citizens United. But they're not doing regs. So the lawyers who help draft the regs for the commissions to consider, I think there are enough lawyers there. They're just not being asked. I mean, I'm sure they're doing stuff, but I don't think underfunding is the problem. It's the way the commission's designed.
So Bill, may I ask a question? I have a couple questions. for
Yes,
you.
you can, of course.
So the issue of PACs, and these are two questions. One, the Florida issue where DeSantis has this PAC and he's going to run, he wants to move it into a super PAC. Isn't that illegal? And then the second question, which is much closer to Virginia, of course, Governor Youngkin has a PAC, the Spirit of Virginia, that has attracted millions of dollars from billionaires in different states. And he can't run for office again. So what can he do with that money apart from just giving it to candidates? He can't roll it into to running for office, right?
I'm sorry, this is who?
This is Youngkin, Governor Youngkin, who has this.
Yeah, the rules here have to do with state money versus federal money. So if you're a candidate, you can only take, it goes up with inflation. It's about $3,000 per election per contributor. So if you've raised money in a state PAC, you can't just give it to your federal PAC. In terms of super PACs can take unlimited money from anybody. So the issue there might be, are there state laws about what can happen to money raised under whatever Florida's state system is? I know CLC just filed a complaint against DeSantis, but I haven't read it yet, so I'm not exactly sure what it says. But it has to do with the rules of you can't, like, if you ran for governor one year and then decided to run for the Senate, you can't just take your war chest from your state election campaign and put it into your federal, because you're mixing state and federal dollars. So that's prohibited. But super PACs can take money from anybody except foreigners. So then I think you would look at the state rules about what they can do. In terms of a war chest, it used to be that federal candidates could, when they retired, could keep their campaign war chest for personal use. They did away with that, I think, in the 90s. They can give it to other candidates. They can give it to the party. There are limits on how they can transfer it, but they can kind of spread it around. They can give it to charity. You're allowed to, like, if you want to give it to the Red Cross, that's fine. The danger is you give it to the NRA or the Planned Parenthood, and then they turn around and spend it on independent expenditures for you in some other race. So there are shenanigans that can take place with that. But the general ban on war chests is you just can't spend it on personal use. And the other thing that you may have heard of are so-called leadership PACs. So if you're Mitch McConnell, you can set up a leadership PAC, and it's a PAC. It can only take money up to the $5,000 PAC limit. But the idea of a leadership PAC is that none of the money can be spent on him for his race. But if he wants to take a trip to Yellowstone to see how the environment is doing, and that has nothing to do with his candidacy, then the leadership PAC could pay for that. I think Sarah Palin's leadership PAC paid for her to do all sorts of things around the country, purportedly because it wasn't going to further her candidacy in anything. So leadership PACs are another problem. There's a loophole in the federal law. Leadership PACs, they should have a rule that says you can't, whoever the leader is, can't use his leadership PAC money for his own personal use. That is a gap in the law right now.
And I think Heidi has a question, right? Is that a?
Yeah,
Well,
I-
will Citizens United will be overturned?
yeah.
I think Citizens United will be overturned. I'm not optimistic that it'll happen in my lifetime. I'm 64. In terms of what Congress can do, the main thing that Congress can do is deal with the issue of coordination with the corporate money and deal with foreign corporations. There are various proposals about how to deal with corporations. If you go too far, like if you say that any corporation that's taken 1% of its money from foreigners should be deemed a foreign corporation, I can picture Chief Justice Roberts saying this is nothing but a blatant end run around Citizens United. This is ridiculous. We propose at CLC that if a company has gotten 20% of its money from foreigners, that it should be deemed a foreign corporation, or foreigners have anything to do with how the money is spent on US elections. So there are various proposals that are out there. Congress could certainly step in if they like. On how it would play out before the Supreme Court, we'll know when it happens.
I think that's interesting because the bill that was introduced in Virginia on foreign influence corporations, the threshold was 1% of ownership and then 5%. And I think if it was just passed in Minnesota also with the same threshold.
Yeah,
So-
there's a group called Free Speech for People, and
Exactly.
their heart's in the right place. We like to work with them when we can. We're a little bit more cautious and centrist at Campaign Legal Center. They would like to have 1% and 5% thresholds, meaning if a single foreigner owns 1% of the company or a group of foreigners owns 5%, it should be deemed foreign influenced and therefore subject to the ban on foreign spending. Our preferred percentages are 5% and 20%. We just think that those are more defensible in court.
Okay, just on the constitutional amendment, I guess from American Promise, we're hoping that, we can get something passed by July 4th, 2026. Although that would be the next general, the next Congress. But basically, we've got 21 states that have already signed on, and in Wyoming, actually, their General Assembly was on track to pass a resolution to support overturning Citizens United, and then they lost 4 votes. And there are even in Wyoming, they had local resolutions by communities, very conservative communities. I mean, the consensus among the American people is that we need to get money out of politics, and they support a constitutional amendment. And even on the state level, I think we can, in Virginia, we have a legislator, a senior senator, who said he's willing to launch a letter of support to allow Virginia to support this and pressure our Virginia congressional legislation to support a constitutional amendment. The issue is whether Congress would do that. And obviously you don't want to go to the Article 5 convention route, which is what we did the last time we did it was the constitutional, they overturned the Articles of Confederation to create the Constitution. But I think that this is time, and it's interesting, David knows this, you look at our history in terms of constitutional amendments, and eight of our amendments have overturned previous rulings by the Supreme Court. Whether it's the 19th Amendment to allow women to vote, the 18-year-olds, the elimination in the poll tax. So it's in times of civil strife that people need to stand up and support reform. So
well, I think a constitutional amendment would be great. I encourage people to have that one of many baskets to put your eggs in, because at this point it's a long haul. So I'm thrilled to have the pressure there for it, but there are other things we can do in the meantime that are more likely to come to fruition in the shorter term.
Yeah, so it's 8 o'clock and I just wanted to share something that we're excited about in Virginia, and that's basically we have recently launched a new good governance website, and basically it's 10 questions that we're posing to every single candidate in Virginia. As you know, this is really the most competitive elections in Virginia in a generation because of redistricting. So it's, where do your candidates stand on good governance? There are 10 questions, 5 related to voting rights, including restoration of voting rights for felons, ranked choice votings, and then on the whole transparency and accountability, 5 questions on campaign finance, whether it's on, I wanted to put in public financing, but we have limits, we have disclosure, we have restricting personal use, and we also have ethics reform. So we're really encouraging, I noticed that Monica Gray, who's a candidate, is here, and as well as others, we're encouraging every single candidate, Republican, Democrat, let's stand up for good governance. But at the end of the day, we're a group and we really depend on citizens around the state to raise their voice and saying, this is an issue, this isn't a right or left issue. Everybody cares about good governance and having government work for the people. So David, unless Bill, unless there are any other pressing, anybody want to raise their hand? Just wanted to.
Yeah, Lily, Lily, are you from Minnesota?
Yeah, I think Lily works on
Yep.
public financing of elections, right?
I'm from Minnesota. I am the director of We Choose Us. We work on voting rights and democracy reform writ large, but I've been working on public financing and just passed the ban on foreign influence corporations from spending on our elections.
And you mentioned that you're being sued on that.
Yes, a lawsuit was filed by the Chamber of Commerce last week, and so we're trying to figure out next steps in the plan there. Our attorney general's pretty good on this stuff, but just been hearing whisperings of our allies worried that the 1 in 5 are gonna hold up in court.
Well, Lily, we'd like to, I know that Elizabeth Schimmick from the Campaign Legal Center said she mentioned your name, and we would really like to have a conversation. We're planning on these Democracy is Brewing in Virginia sessions. We're hopefully in September, we have the people from Oregon who just had their limits bill defeated, but they also have the beauty of being a ballot initiative state. We're going to have them on, along with, we found a legislator here, a couple legislators, 1 senator and 1 delegate who is willing to introduce it. We'd like to have people like Lily come on and look at the issues of public financing of elections. Maybe this year, with luck and everybody in this room contributing, we can have some campaign finance reform in Virginia. I'm probably more optimistic about that than federally. I don't know what you think. What's your optimistic ending note, David?
Well, I gotta be honest, nothing's gonna happen in Congress. I mean, we were delighted that they did reform the Electoral Count Act that had bipartisan support. It's possible you could have more disclosure of the internet ads that I mentioned that aren't subject to the same as TV and radio. But I'm not optimistic that Congress is going to do anything particularly important in this area for the time being.
Yeah, maybe when Mitch McConnell retires.
Well, and the House is controlled by the Republicans right now.
Yeah. Anyway, thanks so much. Thanks, David. It was really a great discussion. Thanks for everybody, and we'll keep everybody involved in April. Just checking to see if you saw my email. Okay. Yes, we're definitely going to start working on ethics reform, and we will get a couple bills at least passed this year. So.
Okay. Well, thanks for having me. Good luck, everybody.
Thank
Thanks.
you.
Bye.
Bye-bye.
Thanks, David.